Thank you all for joining our webinar today on collections in a pandemic. We have Tim Sellers with us, who is going to lead the presentation. The presentation will approximately run about 50 minutes, and then we'll open it up for Q&A. So there will not be questions during the presentation. So if you can send in those questions at the end, happy to help facilitate those questions. As a reminder, we do post our webinars on our website. So if you want to invite other board members to view the discussion today, it will be available for everyone to see. So Tim Sellers, he's been practicing in the Charlotte area for over 40 years and very good resource for all things HOA related. So thank you, Tim, for joining us today. We look forward to your discussion, and I'm going to hide my screen and we'll let you get started.
All right. Thank you very much, Ben. I appreciate that. And I appreciate everyone who's joined this afternoon. I think it's a rainy day pretty much everywhere that any of you may be today. So we'll try and make good use of the next 50 minutes as we talk about a topic that I think is particularly relevant for this particular point in time. And we'll go over some of the particulars as to why that is the case. And as we do that, I do want to be sure I make this clear. These types of events are very helpful when I or other folks present in a situation like this. We're trying to provide general information that is helpful. But sometimes the general information we provide may not apply specifically to the situation that you have in mind. So my reminder is always that when you hear something here that piques your interest, always follow that up with the professionals with whom you work, your community manager, the lawyer that your association works with. We hope that's us. And for some of you, I hope that's the case. But always work these things out in your specific situations with the professionals you work with. We're in a very new time, and there's a phrase that's been used and perhaps overused to describe the last many months, and that is the new normal. I hesitated to use that, but then I thought, in this particular topic, the topic of HOA collections in this particular time, we are in a very new time. And that what we're experiencing now is very likely to become more the norm on an ongoing basis than we're going to see a return to the way things used to be. So it's appropriate for us to talk about the changes that have occurred, the new reality that we are all facing, and so that we can adjust and prepare ourselves to meet that in the best possible way. And of course, the thing that's created this new normal is this virus. And you can listen to any particular newscast at different times and find your flavor of the month as to whether the virus is going to disappear by Sunday morning or whether it's going to be here for another 3 or 4 or 5 years. The reality is somewhere in between, but the fact of the matter is there are going to be long-lasting impacts from the coronavirus and its economic impact on people, as well as the other impacts that it's had. And it's touched all of us, and will continue to do that. And the associations that are trying to adjust to the changes that have occurred in the lives of their members. And the problem that we have is that this really is not a part of our normal. Money does not grow on trees. And so we still have bills. We still have responsibilities that need to be fulfilled. We still have vendors that need to be paid and obligations. And so we have to find a balance. We have to find the ground that takes into account all of the facts and circumstances and strikes a reasonable balance among all of those in our collection efforts and how we deal with our members. So as a part of that, we also need to be aware of the fact that there are going to be some roadblocks. And we believe that those roadblocks are going to come from two potential areas. The first is from the courts. And I will tell you that we are encountering new attitudes, different perspectives from judges, from hearing officers. For example, the first set of hearings that we managed to get scheduled in Mecklenburg County for our clients We had approximately 25 hearings that had been held for some period of time because of the pandemic. We went over for those hearings. In a large number of cases, people did not show up, but the hearing officer announced that she was simply going to postpone all of the hearings for 60 days, even if no one showed up because of the pandemic. We were just going to wait another 60 days. Many of our clients have been waiting 3 or 4 months for action on their cases. But that's the kind of perspective we anticipated. Fortunately, we were successful in getting the hearing officer to agree that if no one showed up to object, it would only be a 30-day postponement. And we're now beyond that. And so we have things moving again. But that's the type of attitude that I think we can encounter. About midday today, one of my colleagues and I had a conversation because we were in court in York County before the master in equity there, and learned that the master is going to now insert a new step in the foreclosure proceeding. Even after we obtain a judgment of foreclosure, there's going to be another hearing to be sure the owner has an opportunity to be heard and an opportunity to try and resolve the matter. So we have the proceedings down there being enlarged under the equity powers of the master in South Carolina to more than they were previously. And the master there, Judge Weaver, told us today that there are other masters in South Carolina who are doing the same thing. Don't know that. I just know that it's happening in York, and that's the kind of thing that we're seeing. The other thing that I think we can expect, or we need to be ready for, is the legislative roadblocks. Right now, there's a lot of debate at the federal level over the stimulus package and the fact that the HEROES Act was adopted in May by the House and the Senate has not acted on that. I can tell you that buried in the HEROES Act at about page 1000 to 1015 is a set of legislation that would absolutely stop any kind of HOA collection action for an almost indefinite period, for the period of the state of emergency declared by the president, plus an additional 120 days, however long that goes, and would automatically impose mandatory repayment plans, which will be longer and longer depending on how long that delay period is. It would absolutely stop any ability to collect assessments. And we have an election that's coming up in some 40-something days, where there may be a considerable change in the complexion of one or both houses of Congress. So those roadblocks may be coming, and some of those may be very, very high. And so we need to be prepared for that. And frankly, if there's an opportunity to speak to some of our legislative folks to encourage them to not pass those kinds of things, which will put us in a very, very bad way. But this new normal requires that we need to make some adjustments, and we need to make some adjustments in several areas. 4 to be exact: adjustments in our attitude, adjustments in our actions, our expectations, and our planning. So let's take those one at a time. First, COVID-19 collection attitudes. I have coined a phrase which is compassionate collections, and that's collection action, which is carried out with a sympathetic consciousness that there are folks out there that are really in distress, and they're in distress not because they've been irresponsible, but because of all of the fallout that has come from this pandemic. It's not anybody's fault. So it is particularly appropriate that we are sensitive to the fact that there are real hardships out there, and that they are not all of the owners' fault. At the same time, forgiveness, the absolute release of someone from any responsibility, is not a part within the fiduciary authority of board members who are responsible for seeing that the association operates in a financially sound and reasonable manner. But there is a balance there. And just because that balance may be hard to strike doesn't mean we should not be trying to strike it and strike it well. But that requires an adjustment in how we look at things, possibly. And that's appropriate at this point in time. The second thing I want to encourage is relative consistency. And that is that if we're going to take collection action or take collection positions, we take similar actions in similar situations, not the same action in all situations, because that won't fit. One size does not fit all. a couple of months ago, we got a call from someone who was complaining about the fact that we're in the midst of the pandemic and the association was pursuing collection. If you look at the file, we found that this person had been delinquent for 2.5 years, had 2 lender foreclosures in that period of time, as well as a bankruptcy. The pandemic didn't have anything whatsoever to do with their failure to make payment. And so that situation is not appropriate for the same action, potentially, as where someone has been faithful and responsible in their payments, now finds themselves in a difficult situation that you're trying to deal with. So compassionate collection and relative consistency. I also want to encourage you to take the initiative to help people pay. Reach out to them. We actually reached out to our clients and communicated that we encourage them to put in their initial letters in the same way that you see on some television commercials right now. If your financial situation has been impacted by COVID-19, we may be able to help. Reach out to us. Tell us. That is a win-win situation. If they reach out, we find out about a situation, we might be able to deal with it more promptly and effectively. If they don't reach out, we know that we've tried it. And so we're able to tell hearing officers, we're able to tell the masters in equity that we actually have been proactive in our attempts to do that. The second point's already up there is continuous monitoring, where that some boards will only meet, goodness gracious, every quarter. That's not often enough in this situation. Things are changing weekly, if not daily, in our situation. And monitoring the status of your collections on a quarterly basis is not enough to ensure that you're acting promptly and you're remaining nimble enough to adjust to changing circumstances. This may come as a surprise in urging less policy rigidity and more process flexibility. We are in favor of, we encourage associations to adopt policies to try and ensure that there is consistency, not uniformity, in how we approach collection situations. But in this particular time, we believe it's appropriate that there is more process flexibility in applying those policies that we have. Proactive communication is very, very important. And I've touched on this, reaching out to members with general community-wide encouragement. Let us know if you're having a problem. Soliciting communications if people are enduring hardships as a result of COVID-19. You see the provision in purple there in the middle of the screen, which is what we have suggested to our clients that they consider. And again, the benefits are that there's a possibility of earlier payment, more reliable payment without the expense and time of the collection process. And in every event, it shows the good faith of the association in trying to adjust to and address the particular situations that are involved. Act promptly. And the first step is to decide. And that involves boards having communications before we are faced with a particular situation to decide what sort of arrangements might be acceptable to us, and to determine what those parameters are in advance, what the range of things we can consider are. And when those specific situations arise, then we can memorialize those decisions and the reasons we have for them, and then respond promptly to IPA, installment payment agreement, and DPA, deferred payment agreement requests, or to settlement proposals. And a settlement proposal is anytime someone proposes to pay less than the total amount that's due. An IPA or a DPA may involve a settlement of an agreement to accept a lesser amount, but often involves just an agreement to accept the full amount that's due over a period of time, sometimes with a deferment or a delay at the front end. But these are complicated decisions to make. They need to be made on a case-by-case basis. So preparing to make those decisions in advance will position the association and the board to be able to respond promptly. One of the biggest frustrations we have as lawyers is when we have owners who make proposals and then we communicate it to the board through the manager often, and we can't get a response one way or the other. Yes, no, maybe, other terms. We just can't get a response. And repeatedly, we find ourselves then in front of a hearing officer, and the owner comes and says, it's been 2 or 3 weeks. I made a proposal. They didn't respond. And I can assure you that almost all the hearing officers will say, well, then we'll just postpone this for another 60 days until they can get around to responding to the request that you've made. These responses need to be promptly made. They need to be thoughtfully made. So we need to think about them in advance. Second point, and this is probably the most important point that I'll make in the entire time that I'm talking with you today. It is essential, it is critical that you promptly file claims of lien. A claim of lien is what perfects your position, and it needs to be done now if you have a delinquency, and it needs to be done right. Because the whole lien process takes a little bit of time. You have to send proper pre-lien notices once an account is delinquent. That's required for you to file the lien and to recover attorney's fees. So the process is not something that can be started hastily if you're going to have full protection. The lien that you file secures all sums that are due, as well as sums that come due after the lien is filed. So when you get it on record, the protection is for the past amounts as well as for amounts that come due later. And so it is very, very important that associations put themselves in the position of being able to collect the maximum amount that is going to be available. The lien is enforceable for 3 years. Now, that doesn't mean that you should wait that long to consider enforcement. In fact, you shouldn't. But that's how long your position is secured. And it is essential to be secured because of the risks that come. Bankruptcy. If you don't have a lien on record and a bankruptcy is filed, you're unsecured. Count on getting nothing. Lender foreclosures. There could be a sale of the property. I had a client contact us the other day and said property was closed and was sold, and the closing attorney didn't contact us to find out the amount due. We've got several $100s in delinquent assessments. Call the attorney and tell him to pay. And I had to say, did we have a lien on record? Well, no. Well, then there was no public notice that there was an obligation due. And in North Carolina, the lien perfects the position. They need to be put on record so that we are in the strongest position possible in light of all these risks. And I've already mentioned the possibility of some moratoriums that are coming. If there's no lien, hear me, no security, no priority, no protection. So no excuses. We're not mincing words here. This is essential. It's critical. To delay is to decide that you do not care about the money you are not liening. Okay? That's money you don't mind losing. If you want to make that decision, that's fine. I think that's a hard decision to explain to the members down the road, that we just decided we would not take this action, which protects us and secures us. And as a result, we were unable to collect assessments that we might otherwise have been able to collect. So promptly file claims of liens. Now, what about interest and late charges? From the very beginning of this time, we have had people saying, well, why shouldn't we just waive interest? Shouldn't we just waive late charges across the board? Well, we did not recommend that because one size does not fit all. That would have been completely inappropriate in the situation I described a few minutes ago of someone who's been delinquent for years. And it's for a lot of different reasons had delayed the association's collection of amounts due, causing neighbors to have to fund the deficit for a considerable period of time. So blanket waivers are not what we recommend. Now, case-by-case waivers of one or both are okay. They may be offered as an incentive for immediate full payment. You may offer that to the entire community, that we're going to waive interest and late charges and allow folks who have balances due to pay those by a specific time without interest, without late charges. There will be some who might complain about that. I hear that, but I think that's justifiable. I think it's particularly justifiable in the midst of this situation that we have to endure some complaints from folks but I don't think there will be any real legal problem that would arise from doing that at this particular time. Certainly, it's appropriate to consider that and offering it as part of an installment or deferred payment plan. You don't have to do that. The waiver may be full, it may be partial. If it is, then it's critical that that be very specifically set forth so that there are no misunderstandings rather down the road as to who was going to do what or what was going to be waived, and never waive the interest or late charges except upon full compliance. So it's not waived now on your promise to pay, it's waived later on payment received. So that's how we recommend addressing interest and late charges. Now, what about foreclosure in this particular time? Well, foreclosure has to be specifically authorized by the board. And so I encourage you to think not can we do it, because you can, but should we do it in this particular situation? There are circumstances where it's certainly justifiable not to move forward because you're aware of the particular hardship. Maybe they've reached out to you and they let you know about their situation. So it's appropriate to try and find another way to address that. It is also a time where we need to be particularly careful about the properties that we decide to take this kind of action on. In the best of times, an abandoned property is the least likely property that's going to produce payment because it's empty and nobody cares. A property that's occupied, a property that's rented, much more likely to respond to enforcement action if it's commenced. At times I've given clients an example of you have an abandoned property and there's $6,000 due on that. You have a property that's being well kept and is occupied, and there's $1,200 due on that property. Which one do you act against first? Well, lots of times people say, well, of course you go for the $6,000. That's the money that you're less likely to ever get. So you need to evaluate these in light of the reality of people's circumstances and the reality of when and whether payment is actually going to be made. Choose wisely, as I was just talking about, and assess that payment probability. It's only effective if the owner cares and the owner can, and that can part of it is what is of heightened importance during this pandemic. There are some people who right now can't. I was listening to the news this morning, and it's a terrible circumstance rather. That's what's happened with respect to unemployment payments. People are entitled to it, they can't get it, they haven't gotten it for different kinds of reasons. So the government is struggling to get relief out to people, and people are struggling in the midst of this, which is why we have continuing moratoriums on the mortgage foreclosures, certain mortgage foreclosures, and even moratoriums on evictions. I hope we don't encounter that. I hope we don't have that imposed on us in the HOA area, but we may. I think the more responsibly we act, the more appropriately we try and conduct ourselves, the less likely that we will encounter that kind of thing. So we'll just have to see. If you are going to foreclose, then at this particular time, we are encouraging you to be very slow or to forego entirely trying to foreclose to enforce fines. Why? Because they are the most bitterly resented of charges. Fines are imposed because someone has done something wrong. They have violated. It's not that they didn't pay what everybody is required to pay. It's because they have been a bad person. And so they are bitterly resented, and they are resisted and opposed aggressively. And so if you lump your assessments and your fines together, then there's a greater likelihood of resistance and challenge. You're not going to forego them completely. You would simply set those aside and not pursue them at this particular point in time. And so that's why we encourage tracking those separately from assessments, because we believe that by either slowing that process or foregoing it this time, we'll avoid challenges from owners and from the courts. And then finally, and I've tried to make this point, and I'll make it again, accommodate COVID-19 hardships. Hopefully people will reach out. they will let you know what their circumstances are so that we can make appropriate adjustments. And those adjustments often come in the form of installment or delayed payment plans, where we allow someone to pay less than all that is required, or to delay the initial payment and then pay in installments because of the hardship they are encountering. And I have suggested this in other forums, and one of the immediate things I get back is that people will lie. People will make up things. Well, yes, they will, and yes, they have. Well, that still doesn't mean that we should not be looking and trying to be sensitive to verified hardship. And when you're allowing people special terms and special conditions, there is nothing at all inappropriate with saying, we need verification of your hardship. We need it in writing, please. And that way you keep that record. So if someone questions, why did Sally and Tom get to delay their payment or to pay in installments when the rest of us didn't have that particular option? Well, they were involved. They made us aware of this hardship, and we felt it was appropriate to allow them these particular terms. And I don't think that you're going to encounter any problem with that. From people will threaten, we'll sue about that. I just can't see a judge or a hearing officer anywhere being upset because an association has been thoughtful in trying to deal with an individual situation. I've seen the reverse, where it's been clear that an association has been callous and unresponsive. And I've seen hearing officers, judges, and masters respond very negatively, let's say, to that. So approve them if there is a verified hardship. Second, always secure any installment payment agreement or deferred payment agreement with a claim of lien, because you're going to delay your payment. You're going to agree to take payment over time. And so it is essential that that obligation be secured, be perfected, and the only way to do that with a claim of is with a claim of lien. An installment payment agreement, a deferred payment agreement, even the best drafted one, does not accomplish what the claim of lien accomplishes. So it's a two-part approach. The claim of lien is as important as the installment payment agreement. When you allow those, preparation and administrative costs are collectible. Those may be collectible upfront. We require a payment initially, or they may be folded into the plan payments. Of course, the more that someone can pay up front to cover the administration cost, or potentially the cost of preparing the IPA and filing the claim of lien, the better, because it means the association has recovered those costs and is, at least to that extent, whole as it waits for the remainder to be paid in accordance with the terms of the agreement. So try to collect those if you can, those costs and any prior fees that are paid. There are defaults on these agreements. There will be defaults on some of these that you enter into. So the more that can be collected up front, the better. Always a good idea to require future payments by bank draft. That way, the payments are automatically coming in to the association, and there is a level of notice that occurs when a payment does not come in at a particular time, that the account has been closed or the account has insufficient funds. So we think that's an appropriate and important component of these types of plans. Keep accurate payment records. Once there's an agreement that this is the sum due, these are the amounts that are going to come due hereafter, here's how it's going to be paid, here's when the payments are going to be started, all those details are ironed out, then it's absolutely essential that the payment records that are kept match what's in the agreement, so that if there is a default and we have to be back in front of a hearing officer, a judge, or a master with it, we will show this is what the agreement was, here's our payment records, and everything lines up. So keeping those records and keeping them accurately is very, very important. As is the payment plan paperwork. It should always be in writing. I'm amazed at the files that sometimes come over our office, and someone says, well, we're in a payment plan, And well, it was just a verbal. They were just going to pay this much a month. That's crazy. That's not a payment plan at all. So they should always be in writing, signed, and I believe they should be notarized. They can get these things notarized, and that's the verification that when it comes in, it was signed by the person whose name is on it, not by their brother, not by their spouse, because we've had those situations. I didn't sign that. That someone has fraudulently put my signature on it. So we have to try and be prepared for that by putting these in proper form, getting them signed, getting them notarized. If in this paperwork, if there is a past claim of lien filed, or the owner is consenting to the filing of a new claim of lien, which is critical if one's not on record, the agreement needs to certainly confirm all of that in specifics, that the lien is valid or that we're consenting to a new lien. And then there need to be appropriate provisions in it where there's a waiver or acknowledgement of statutorily required notices, because some of these discussions may occur before the pre-lien letter has been sent. And remember, that pre-lien letter is a prerequisite for filing the claim of lien. So it's essential that these agreements be comprehensive in their waiver of notice requirements, their waiver of any other rights under the law, because you're allowing special arrangements. If you're allowing special arrangements, it's not inappropriate. In fact, it is quite appropriate to get all of those additional assurances. And then finally, and this probably seems like it'll go without saying, detail all the charges, all the fees, and all the costs. These situations are ones that are there can be misunderstandings unless an attempt is made to ensure that the paperwork is abundantly clear. If there's going to be a delay period, and this is one of those areas where it's important to be clear, that needs to be specified. How long is that? When do payments begin? When are payments to be made? All of those details need to be set out in the installment paperwork. You need to address the payment of future charges, because sometimes these payment plans extend over a period of time and we're not sure what the assessment is going to be for 2021. It may change, or whether there's a special assessment that may arise. Although we're going to encourage at this point in time, if you can delay major expenditures, that's an important part of potential planning. We'll talk about that. So, but address the payment of future charges, and then include, as I've already mentioned in one respect, protective terms, admissions of liability, consents to enforcement, to the entry of a judgment, waivers, releases. We pack all of those into the IPAs that we create for our clients after a file is in our office and an owner requests terms and terms are approved. So we make sure those are in there. They need to be in every IPA or DPA, regardless of when it is created. So because all of these terms are important, have your attorney prepare these. Even the ones that occur prior to the time a lien has been filed, someone's responding to your invitation for them to tell you about their situation. Have the agreement, have the claim of lien prepared by your attorney so that you can ensure and have the assurance that it includes everything that's appropriate to give you the association the maximum protection, and you get that claim of lien on record. We have offered out to our clients a particular new request that they can make, which is they've agreed to terms, and we've given them a fee for the preparation of both the IPA agreement or the DPA and the claim of lien for matters that have not been referred to our office, because we will ensure that those documents are appropriate, have the terms in them that they need to have to fully protect the association. So that's my encouragement to you in this critical paperwork, which we're likely to see more of at this particular time than we have in the past. So what about expectations? What can we expect in the midst of this pandemic? Well, we can expect bankruptcies to increase. And again, no claim of lien, no payment, ever. No ifs, ands, or buts. If you don't have a claim of lien on record, if bankruptcy is filed, count on getting nothing. So don't get caught by surprise by that. Lender foreclosures are being delayed, right? So we've got deeds of trust foreclosures, mortgage foreclosures in South Carolina that are being delayed because so many mortgages are federally backed, and we have this moratorium that's going on. That will come to an end. Once they come to an end, those lender foreclosures will begin. And unless somebody's fouled up, our liens are typically junior, subordinate to those mortgages or deeds of trust. We're second. So right now we have a little bit of a reprieve because, frankly, some other folks are being prevented from being proactive in their collections. That won't last forever. And when it comes undone, then we're going to see maybe not an avalanche, but we're going to see a dramatic increase in the number of foreclosures that are filed by lenders once they're able to do that. Uncollectible amounts, bad debt is going to go up. Very few associations anticipate bad debt. There is going to be some this year and next. So anticipate that. You may anticipate that in your budgeting process. We see very few associations that will create a bad debt reserve. I think that's a wise thing. If you end up collecting more and you do not need your bad debt reserve, then the association is just that much to the good, having planned for that. So, but there are going to be uncollectible amounts. And they're going to be uncollectible, not because people have done anything wrong, because they're just going to find themselves in some difficult circumstances that they cannot extract themselves from it. And we're all going to suffer through that to some degree, and associations will suffer that in the form of some increased bad debt. Conducting business as usual. We're just going to do it the way we always have been. Then you can count on less money coming in and higher unrecovered amounts and cost to pay. So, those costs will go up, and not only will they go up, but the likelihood of recovering them will go down. So we want to encourage you to think differently, to anticipate these new realities, this part of the new normal, and to begin preparing for it. So how do you plan for this kind of thing? And we could have another whole hour talking about the various ways that you might plan to address these types of situations. First, reduce or delay expenditures. If there are discretionary expenditures out there that can be put off, then put them off. Even if you may have funded them now, because there may be a need for that cash to go to other places if that's permissible, if it wasn't collected for a specific purpose. You've just been building a fund for it, for example. So there are some things that cannot be delayed. You have an obligation to maintain buildings, for example. You have an obligation to maintain a roof and it's in need of repair. Well, that may not be something that can be delayed, but there are some things that are. And try to be objective in your board meetings as you're wrestling with those things to really sort out, do we really need this right now? I mean, really ask that question several times. If we don't, then maybe put it off for a period of time and explain to your membership why you're putting it off because of the realities of the current year and the challenges that we're facing. You may want to adjust the budget. If you do that, that's often possible. Then be sure you follow the proper process. If there's a new budget that comes out, there may be particular notices that need to go to the membership that may need to have an opportunity to ratify, or in more cases, potentially reject a revised budget that may include a bad debt reserve or may adjust expenditures to try and accommodate what we're finding, the challenges that we're faced with at this point in time. So don't overlook the possibility of adjusting the budget, or at least exploring that as a possibility. Create and protect the surplus. Very few associations run a surplus. Many of them should. and they should try and create that surplus for the purpose of funding reserves, not just for the purpose of having a surplus, because frankly, under the statutes in North Carolina, both the Condominium Act and the Planned Community Act, if you have a surplus, then that the law requires that that surplus either be returned to the members or offset as a credit against future assessments. So when you create that surplus, and I talk about protecting it, I'm talking about as a part of the budget process, providing for reserves specifically, and then providing also that should any surplus result at the end of the fiscal year, that will be allocated potentially to a general reserve fund, so that it's not really a surplus, it's just extra funds, and our budgeting process provides specifically that should we have additional funds, unspent budgeted funds at the end of the year, they will be allocated to reserves for future uses. So, and there we are, establish and reallocate reserves. If you don't have reserves, it's appropriate to look at establishing those. You may have reserves at this point in time, and they may have been created for a particular purpose, for road repairs, for roof repairs. If those funds were collected for that purpose, then there may be some steps you need to go through if you want to free up those funds for other uses. And you need to take care to take those steps so that no one will have a legitimate objection that funds have been used for an improper purpose. You took them for one reason, you may have had a good reason to use it in another way, but you didn't go through the steps to get the appropriate approvals for that. So that's not an automatic right or option, but it is one that you might consider. I was talking with a client within the past 4 or 5 weeks that accumulated over $100,000 in a particular account that had a lot of strings on it. And in fact, given the strings that were on it, it's very likely that those reserves were never going to be called on for use. Well, but they had these other needs over here that were acute and immediate. And so we began wrestling with how do we free up these funds that we hold over here so that they can be used over there. So that's just something that may be an option to try and deal with the cash crunch that comes. And then finally, perhaps a loan. Now, of course, if you're going to get a loan, then any lending institution is going to be interested in you establishing the ability to repay that loan out of the assessment stream that you have. So that may or may not be a legitimate possibility as a part of your planning. So that covers, in a nutshell, some of the major points that we have come up with to try and bring to the attention of our clients in trying to deal with the challenges of the pandemic. You may have other ideas or questions. And Ben, what are we seeing? Do we have any questions?
Well, a couple of questions have come in, and I think a few more may arise. But so first one, we have a claim of lien is filed for a certain amount.
Yep.
Can future monies be added to the claim?
Was it can future monies be added to it?
Yes. Can future money be added to the claim?
All right. Well, let's talk about North Carolina first. Okay. In North Carolina, the statute provides that the claim of lien secures the amounts that are due and future amounts that come due. So there's no need to update a claim of lien with a new amount because the statute provides that it secures amounts due and amounts that come due, even if they're not specifically listed. So we're statutorily covered in North Carolina. In South Carolina, we do not have the statutory structure that we have in North Carolina, so the documents govern. I can tell you that there's some debate as to whether even a notice of claim of lien or a notice of delinquency and lien is even required in South Carolina. We file them, and we file them to try and give public notice of the association's perfected and matured claim. And we put in our liens that they secure the amount due and amounts that come due thereafter. We've never had a problem trying to collect that, but it is not as certain in South Carolina as it is in North Carolina because we don't have the statutory scheme there. Now I will say this, if you have filed a claim of lien and you have delayed a considerable period of time, over a year, year and a half, then frequently, if there has not been a change in the title, because we were always concerned about priority, If there's not been a change in the title that would affect priority, we will file often a new claim of lien before we foreclose, so the amount is shown in the claim of lien that we're foreclosing. So not a big concern there, because in North Carolina there's statutory protection, and we try and protect ourselves through the liens that we file in South Carolina.
Okay, so follow up kind of to that question: if a claim of lien exists and it's updated every 3 years at the end date or after the 3-year end date, the original lien get extended automatically, or how does the original lien get extended?
It does not. You do not extend a lien. The lien establishes the secured position of the association in North Carolina for a period of 3 years. So if we file a lien and then we just sit on it and we wait until, well, let's take 3 years less a month, and we put a new lien on. Well, that original lien expires 1 month later, and the new lien establishes the association's secured position as of the date it's filed. If there were things that happened in the middle, in that interim period, judgments, new deeds of trust, then they are superior to that second claim of lien. So you can't renew and keep your same position. You get that 3-year window, and our encouragement is, if you're going to act at all, act well within that 3-year window. The other thing you have to keep in mind is that the lien and the 3-year period we're talking about is just the period of time that the lien establishes a secured position. That does not stop the running of a potential statute of limitations on the debt itself. And so you may file a lien after an amount's been owed for years, and you think you have 3 years on it, but the statute of limitations on the debt expires before the lien security expires. We've seen some of those defenses raised. And the statute of limitations in North Carolina, our best guess from the case law that we have is that you should think about 6 years, because the enforcement of restrictions are deemed to be what are called in the law incorporeal hereditament, which I have no idea what those words mean, except that they're just for lawyers. But that has a 6-year statute of limitations. We actually have a case where a declaration was under seal, and the court said it's 10 years in that case. But don't rely on that. Don't delay these things. And in South Carolina, we're counseling that you ought to count on no more than 3 years before that contractual obligation expires. So you have to be cognizant of all of those time periods and not be lulled to sleep to think, oh, well, we're just going to update our lien and we'll be good, because you won't be.
Okay, another question that's more pandemic related than collection related, but high-rise building, and we are having safety issues with residents that refuse to wear masks in elevators and common area lobbies. The only tool that we have to enforce these provisions is the fine and hearing process. What are your recommendations on fine collections and where fines are related to the safety behavior?
Well, this is a collection seminar, and that actually goes beyond the... Oh, wow. People, goodness gracious. I think and I'm trying to, we've actually not had that particular question, but when you have, and by the way, you got to look very carefully at these executive orders to see, to be sure you understand their application, because sometimes these things come over on the news and they say, well, now we got a statewide mask mandate. Well, it's not, in every situation, and how far are you from people, and indoors and outdoors. You need to understand what those things are. But let's take this situation. Let's say that the association, the board of directors, as a part of its exercise of its rulemaking authority and over common elements, says masks shall be worn in the common elements. Hallways, common areas, lobbies, that kind of thing, which are particularly at issue when we're talking about high-rise urban life. So we have a rule. I think you proceed with that with the notice and hearing and the imposition of fines for that particular event. And remember, you get one fine up to through the time of the initial decision, but then there may be additional fines for each time thereafter that the same violation occurs without a further hearing. Now, whether you eventually file a lien on those or you foreclose on those, that we have to wait and see about that, perhaps, for all the reasons that I've talked about. But I would follow through with that because that's what you can do. And that's what I would expect if I was an owner and I was wearing my mask, which I do wherever I am. I would expect those kinds of steps to be taken. If you're not going to take those steps, please don't bother with the rule and create the expectation that something's going to be done. But I am not saying that in every case where you hold the hearing and a fine is imposed, that you immediately then file a claim of lien or immediately then thereafter foreclose it. In fact, the foreclosure part of it, consistent with my earlier comments, I would say you hold off on for a while to see if this is a chronic problem or if someone gets the message. So that's about the best I can do on that. I may be inadequate, but probably the best I can do at this time.
So small claims,
yeah,
and pursuing collections through small claims. Is it ever worthwhile to pursue judgments through the small claims court system?
Well, that's an interesting question. It's an interesting question in a pandemic, apart from the pandemic. Here's the thing about small claims. Can you do it? Yes. If you get a judgment, unlike the situation where when we file a claim of lien and foreclose a claim of lien and we have priority, we have our priority established. If you obtain a judgment and you seek to enforce the judgment, which they're not automatically paid, you have to go through the execution process. You have to go through the process of allowing the owner to lay off exemptions. How much of their house, how much of their personal property, their other property is going to be exempt from the collection process. There are hundreds of thousands of judgments at the courthouse that are just unpaid. And the whole reason, and at least in North Carolina, or not the whole reason, but a large part of the reason and the need for both the Condominium Act and the Planned Community Act was to allow associations a direct lien against property, which can be directly enforced through the power sale process, if necessary, without the need to lay off exemptions. And I had a conversation with the former master in equity in York County in South Carolina, Jack Kimball, who said the same thing to me. And I went through the process with him, was saying, well, Judge, it looks to me like if we pursued a judgment, then at a potential execution sale, the first bid needs to be the equivalent of whatever the exemption is. Am I right about that? So we're actually in a far worse place trying to pursue a judgment than to pursue the lien process, however challenging the lien process may be. So I encourage folks, look, if you want to do that, you're free to do it. I think what you're going to find is the inadequacies of collections using that process are what prompted the statutes and the processes that we now use that are far more effective.
So this may be a South Carolina community based on the question, but if the community documents are interpreted that attorney's fees can only be collected when moving to foreclosure, how are the attorney's fees recovered if it doesn't foreclose?
They are not. And there is a South Carolina case that holds precisely that. In fact, it holds precisely that in the context of a law firm down there that sought collection of fees at the lien stage when the documents themselves said attorney's fees are recoverable in connection with foreclosure. That's why in South Carolina, the documents rule. And we look very carefully at the documents of all our South Carolina clients to try and root out exactly that kind of language, because it's a problem and it can only be dealt with through amendment.
Okay. When should the HOA foreclosure process be started?
Well, that has a lot of different factors to it, as I have identified. You, I think you certainly consider the lien when you have a delinquency. And again, I think a standard sort of response of, well, foreclosure process should be started 6 months later or 9 months later, or when an account gets to a certain amount due. Goodness gracious, if you're in a community that has 35% delinquencies and everybody, it's a very, very large community and everybody owes $500, but our threshold is 750, you're out a lot of money and you're not taking any steps to collect it, the funds that you particularly need. So I think I just need to sort of leave it that you assess that, you talk with your managers, and you approach it in a responsible fashion of getting yourself secured, and then evaluating the delinquent accounts out there and making good case-by-case decisions consistent with a policy that you may adopt, but not get wed to, not get handcuffed to try and ensure that you're consistent in how you're going forward. But I don't think there's a blanket answer for that question as to when should you do that.
Okay, we've got another one. We probably have about time for 2 or 3 more. So,
okay.
Do you have a recommendation threshold for filing a lien in terms of unpaid assessments? For example, if assessments are quarterly, if someone doesn't pay just 1 quarter, do you recommend a lien, or perhaps pay the following quarter if it is also missed? So is it a time frame or a dollar amount?
No, I think it really, you need to look at your particular community. There are communities out there that have annual assessments that are $250. Well, if you have obligations that need to be funded, then to say that, well, you need to wait until 2 assessments are past due, well, that's probably far too long. But if you have a community where it's $175 a quarter, then maybe it's appropriate to wait until that second quarter is delinquent. However, again, we are in a different time, and I don't think that there's it's not inappropriate to look at, okay, we're going to tell people, if you're a delinquent, we're going to file a claim of lien. So we get a quarter that's overdue, and we begin sending the letters out on that, because it's important to us that we secure our position. Now, it may be a much longer time before we take any further enforcement action by virtue of foreclosure, but we secure ourselves in this situation sooner rather than later. And without knowing specifics that are involved and particulars about the community, I may make a statement that's more misleading than helpful by trying to be more specific than that. So I think you think about it, you recognize the realities that we're in, that you secure yourself sooner rather than later, but possibly delay the enforcement part of it for a longer period of time once you're secured, to see if a payment comes in to allow people to pursue an installment payment arrangement or something like that.
Okay, last question, and just kind of paraphrase the question itself, but why do foreclosures take so long?
Why do foreclosures take so long? Well, they don't take so long because of the time frames that are in statute. And I don't know what this particular questioner's time frame is taking too long. Well, there are several factors that come into play, so I'm just going to mention them so you'll be sensitive to this. And I don't know whether we're in North or South Carolina. But sometimes we get the liens filed, and then depending on when we get the authorization, we can get a foreclosure filed in a relatively short period of time. There are times when we contact the hearing officers, depending on the calendar, and we are aware that we cannot get a hearing scheduled for 2 months, 2.5 months, just because of the number of foreclosure hearings that are being scheduled for HOAs for deeds of trust. In South Carolina, the process for foreclosure is a full-blown civil action. we can't serve people in South Carolina by posting. We try not to serve them in North Carolina by posting for a lot of reasons, but in South Carolina, we can't. We have to get personal service. And so at times, it takes months to try and get them served with process so that they then are under the obligation to answer. And if they don't answer, there's the possibility of a default. And then after the default, then we have to schedule the particular hearing. So we find that our procedures in South Carolina get prolonged longer than the ones in North Carolina. But sometimes they're getting longer in North Carolina because we're finding hearing officers that are postponing hearings once, twice, 3 times, usually just because someone shows up and says, gosh, if I had a little more time, I think I could pay 60 days. Now, what we can do is we can immediately appeal that to Superior Court, which increases the cost, and we very often have difficulty getting that heard before the delayed date, and hearing officers know this. So all these factors come into play as we're trying to press the proceeding along, but we have these procedural requirements and sometimes court decisions that prolong it. What I was talking about in York County today, this decision by the master and apparently by other masters that we're going to have an initial hearing on whether you get your judgment. Then we're going to have another hearing to give you another opportunity to come back in and explain why you either need some more time to pay. That's going to expand it further. So the problem is if there's a fault that, I can't say that I'll say that we're prolonging these things. We're doing everything we can to push these things along. And so if you're having a concern about a particular proceeding, I will ask this, because this is what we like to have happen. If you're concerned that a particular proceeding that we're handling is taking too long, then let's talk about it directly. Sometimes your property manager can't answer that. We're your lawyers. You call us, we talk to us, and we can tell you. Our case manager can tell you why a particular case has taken long. And it's not the same reason in every particular case, but rest assured we're trying to press them forward as rapidly as we can.
Well, very good information. Thank you for your time today,
Certainly.
Tim. And I think your contact information is on the screen. I will say, if you do have follow-up questions for Tim or any of the attorneys that you work with, please contact your manager and help coordinate the time to speak with the attorney. So we're always happy to help. So again, this information will be posted online on our website in the board member section at camsmgt.com. There is a separate section for all of our webinars that we've hosted. So we hope you'll visit that and recommend these to your board or your fellow board members. So again, we thank you for your time today and look forward to seeing you next month.
Thanks, everyone.